Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners interested in expert discussions and frontier issues in these fields. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Privacy and Information Security Committee of the Antitrust Law section, and is part of our ongoing series on different approaches to regulating artificial intelligence. Today's episode focuses on the European Union and its recently passed AI Act. As was the case with digital platform regulation and the Digital Markets Act, Europe has come out of the gate first with a comprehensive regulatory scheme to govern an emerging technology, artificial intelligence. The EU Parliament approved its Artificial Intelligence Act on March 13, 2024, and it entered into force on August 1st of 2024, and the majority of its enforcement provisions will go into effect 2 years thereafter on August 2nd, 2026. The Act will apply to the full spectrum of the AI supply chain. It'll apply extraterritorially, and the goal is to support development of trustworthy AI. The Act imposes graduated obligations based upon 4 levels of risk: unacceptable, high, limited, and no risk. The risk categories are determined by self-assessment. The obligations fall primarily on developers, not users. The first category, AI with unacceptable levels of risk, are strictly prohibited. And this category includes AI systems that, for example, permit social scoring or are intended to predict whether someone's likely to commit a crime. The second category, high-risk AI systems, have the most obligations of the remaining 3 categories. And these include systems that deal with, for example, critical infrastructure, employment, essential public and private services like healthcare or banking, and justice and democratic processes such as those used to influence elections. And those obligations include assessing and reducing risks, maintaining use logs, being transparent and accurate, and ensuring human oversight. The third category, low-risk AI systems, just have to meet certain transparency requirements, including informing users that they're interacting with AI and watermarking artificially generated content. And the fourth category, no-risk AI systems, have no obligations under the Act. The AI Act also takes a 2-tiered approach to the foundation models that form the core of AI systems. And general-purpose AI models that present low risk will have transparency obligations, need to comply with EU copyright law, and be required to publish detailed summaries of the training data. Models that prevent systemic risk will be subject to more stringent obligations, including model testing, red teaming, risk assessment and mitigation, and reporting serious incidents to the Commission. As we have seen in this series, different jurisdictions are taking different approaches to regulating AI in terms of the problems they're trying to solve for, the harms they're trying to avoid, and how they weight risks and where they allocate them. On one side of the spectrum, you have jurisdictions not wanting to stunt new technologies that could become big economic drivers for their countries, while others are worried about doomsday scenarios that pit machines against humankind with dire consequences for the carbon-based squad. As you listen to this and future episodes in this series, there are a couple of questions that we encourage you, the listener, to keep in the back of your mind. First, what do you think is the quote-unquote right approach to AI regulation? And second, is AI proving to be as good as or as dangerous as what we're planning for? Co-hosting this series with me are Rory Macmillan and Nina Jayne Carroll. Rory is a partner at Macmillan Keck, based out of Geneva, Switzerland. And Nina is with the law firm Cleary, Gottlieb, Steen and Hamilton out of London. Excited to have you both back, Nina and Rory.
Thanks. Good to be here again. Thank you.
Delighted to be back. Thanks, Anant.
Nina, can you tell us a little bit about what this episode will cover?
Absolutely. And I think from your introduction, we can already tell how much of a mammoth piece of regulation the EU AI Act is, which is going to be the focus of this episode. So really Europe's answer to AI regulation. And we really want to consider whether this framework is the pioneer that it's been discussed to be, or whether this framework is essentially going to be more of a cautionary tale. It's obviously been deemed a landmark regulation by many people, both its supporters and its critics, and it's sent to send shockwaves really globally and is going to influence AI regulation in many countries in one way or another. So we hope to discuss what we've learned so far about how well the EU AI Act will regulate AI and what its likely future effects will be. And I suppose touching back on what we've learned from the last episode that we had, there isn't just one way to regulate AI, and the EU has taken quite a stringent and prescriptive approach, and we really want to touch on the impacts and the risk that could pose both for end users and for businesses that operate in this space. So we're thrilled to have Caroline with us today.
For our listeners, can you recap what we discussed in the first episode of this series?
Absolutely. So, on the last episode, we really saw how the geopolitical landscape has shaped AI regulation and that there's a myriad of approaches to doing so. So, we obviously have the sectoral and patchwork approach in the US in stark comparison to this prescriptive framework in the EU. And we spoke with Anu Bradford, who coined the term the Brussels effect as to whether the EU AI Act is going to have an impact globally akin to maybe what the GDPR had at the time back in 2018 or not. And I suppose we really fleshed out this clash of acting to protect fundamental human rights versus not acting too soon in order to stifle innovation.
Yeah, as well as that, Victor Mayer Schoenberger from the Oxford Internet Institute, I think he helpfully gave us a bit of a framework around thinking about regulation where things are changing very quickly with a lot of uncertainty. And he suggested you need to make sure your regulatory framework is very human centered and focused on empowering people really to guide outcomes, make decisions, that it be socially anchored in the realities of society and usage, and then lastly, that it had a strong learning, kind of a feedback loop built into the regulatory system so that it learns from how it's working and it learns as the technology is developing. And so it'll be useful to see to what extent we think the EU Act is achieving those things.
Rory, with that as prelude, can you introduce today's guest for us?
Yeah, thank you. So we have with us Caroline de Kock, who's speaking from Brussels. She is a leading expert in European tech policy and law. She works extensively with tech companies, nonprofits on digital rights, access to knowledge, artificial intelligence. She is a managing director and founder of N Square Consulting and Square Up Agency and Information Labs in Brussels, and has done a lot of work navigating the European Union policy landscape and law with digital platforms. Welcome, Caroline.
Thank you very much, Rory, and hi, Nina and Anand. I look forward to dissecting the AI Act and the Brussels effect it might or might not have.
Now, dissecting the act is a 459-page act, Caroline. That's going to be quite a dissection process, right?
Well, I think you can look at it with a helicopter view to a certain extent and look at the big pieces and, more importantly, maybe compare it to the US approach and see how it's in its structure and in its approach.
So, to really get into that dissection of the Act, obviously, we've said it's a landmark piece of legislation and a first of its kind. So, to start us off, Caroline, can you tell us your impression of what the AI Act is trying to solve and how it goes about doing that in terms of its key concepts, obligations, and its timeframe?
Yes, Nina. I think the important thing to realize about the EU AI Act is the time difference between when it was kickstarted and when it was adopted, which was at a moment where AI was exploding in terms of B2C applications, so consumers having access to AI. AI has been around for a long time, but it used to be more of a B2B or research type of set of applications. But suddenly, it came in the public space and it created hype, excitement, and all of those things. And there is nothing more dangerous than hype and excitement and policymakers in the same room because they feel compelled to provide solutions, even though they might not necessarily know what the problems are yet. The AI Act started in April 2021. So that is, to a certain extent, pre-Chat GPT, if you wish. And then as it evolved, the tendency in Brussels at the moment is to adopt acts that try to solve every use case that Brussels identifies as problematic and very skillfully detailed the approach by risks. But you have to imagine that each of those risk layers that the EU policymaker identified were actually associated in their head to some application at that point. They were thinking of something. And that, how should I put it, colors the way in which they then write the solution to a certain extent. It's what I call the use case approach of legislation in Brussels. And I find it a worrisome tendency. It used to not be the case in the past. Brussels used to look more at behavior. So, for example, we did not have an internet directive. When the internet started becoming popular, we created an e-commerce directive because we were trying to manage e-commerce and to regulate behavior there and create some clarity there. But in this case, Brussels decided to go for an AI Act, which is extremely broad.
And so it's covering in there, Caroline, in terms of what that's covering is AI. It's basically anything involving uh, artificial intelligence of any sort.
So it covers any machine-based systems that have the ability to operate autonomously and infer outputs such as predictions, recommendations, or decisions that can influence physical or virtual environments.
So that's
And when
the OECD definition, right?
That's the
That's built on.
OECD definition, but there were even discussions looking at that definition if it could, by accident, maybe cover macros in Excel spreadsheets, because it's so broad to a certain extent that you're nearly saying the AI Act covers mathematics, which is like, okay, that's a lot of things. So it's an extremely broad scope. There are recitals that kind of clarify that no, it's not covering Excel spreadsheets, obviously. But that means that anyone that is active in the AI space needs to look at the AI Act before putting anything on the market in the EU, because it's not where you've created your app or your model that matters. It's as soon as a product is available to the EU market, you fall under the EU AI Act. A bit like the GDPR is extraterritorial, so is the AI Act. And as mentioned by Anand at the beginning, I think also what is interesting is that because of the difference in when the AI Act started being thought about and when it got adopted, the chat GPT emergence or the chatbot emergence more generally made that the regulators, the policymakers felt compelled to add a section, and that is the section on foundation models or general purpose AI. And that section kind of feels a bit, how should I put it, as an afterthought and a bit hurried in terms of the quality of
Mhm.
the language that's in there. I mean, you have to imagine that the end negotiation to adopt the act was 3 days in a row with very little sleep. And it's sometimes, you can read it in the act. There's even pieces of the act where they adopted recitals, but they deleted the article. And so those recitals are floating aimlessly in the act with nothing to, I mean, they're explaining an article that isn't there anymore,
Right.
basically. And that couldn't get cleaned up, sadly, at the end.
So one of the things that we notice with legislation, which starts with a very broad concept, I think we saw this with GDPR as well, where you have a definition of personal data, definition of processing, extremely broad, so that if you take a photograph of somebody with your camera, you're now processing personal data. What you then need to do is walk backwards from that very broad definition and exclude a ton of things. You want to talk us through a little bit how they've done that, things that it doesn't apply to, or the way that they've made sure that they focus the real weight of regulation on the seriously risky stuff and that they're much more relaxed about what's less risky? You want to give us a sense of that?
I think there's two different levels at which they started excluding things. First of all, there's a differentiation they're making between open source and not open source, where the considerations in terms of transparency, for example, are different. There's also, at some point, I think they realized that some of the compliance mechanisms might be quite burdensome for smaller players as compared to the bigger ones. But to a certain extent, that is being pushed back to the code of practices that need to come out, that actually one of them was supposed to come out last week, but that has been delayed because there's a lot of pushback. Funnily, by everyone in terms of the adoption of the codes of practice. It seems that everyone is very annoyed by them or doesn't like the level of detail. The AI providers find it too detailed, whereas right holders or fundamental rights or digital rights activists find it not detailed enough. And even European Parliament intervened, saying that it wasn't completely taking the right focus. According to them, there was too much emphasis on long-term risks rather than immediate fundamental rights risk, for example. So
So you're mentioning the code of practice there. So we have the act itself. That's the
yeah,
459-page document on the PDF, at least that I have on my computer. And then you're saying, in addition to that, there's a code of practice that's being prepared or still being prepared and argued over. Is that in order to understand how the act is going to apply in concrete situations? Or talk us through just broadly what that's trying to cover and why it's such a difficult project to try and get it finalized and adopted.
So The way they adopted this is you have the overarching AI Act that is supposed to cover everything, all types of AI models. And as Anant mentioned, that has a risk-based approach. If you're producing models, AI models that do credit scoring or can really affect people's lives, then you will have more compliance obligations than if you're producing AI that creates spam filters, for example, where you will have no obligations normally. So that's one way of doing it. But then they realized that obviously at some point you can't put everything in primary legislation because then it becomes very unflexible in terms of mechanism. So they pushed back some of the details to future codes of practice that need to come out. And work started quite quickly on those codes of practice because of that staggered timeline of application of the AI Act and the need for those code of practices to be there to allow AI developers and AI importers, etc., to comply. Because at the moment, if you look at the AI Act, you know that you need to comply with something, but you don't know what the something might be because there's no legal clarity on what the details are of the something. Now, so the codes are essentially the detailed guidelines that are meant to provide the practical instructions on how to comply with the AI Act. And the code is supposed to be, let's say, the Bible of the AI office, that is a department of the European Commission that will have to look at compliance with the AI Act, helped obviously at national level with national relevant authorities. The intention of those codes is to be developed through stakeholder dialogues. So basically, you put around the table the AI developers, civil society, rights holders, anyone that is affected by AI, and you try to come to practical compliance measures that everyone is happy with. Or in this case, everyone is unhappy with. I guess that's the approach that has been taken. If everyone is equally unhappy, you have a good code, seems to be the result at the moment. I think the difficulty to start with, because a lot of people say, oh, it's they're trying to micromanage things too much, etc. It's a very difficult balance for the European Commission to provide legal clarity on the one hand, so some measure of detail, but not be detailed to a point where AI developers feel that their foundation models are being shaped by policy rather than by innovation. You want to avoid the joke that usually is said in Brussels, which is the US innovates, China imitates, and the EU regulates. That's kind of the thing. And it might be true, but that doesn't mean that regulation is bad. I mean, if it provides legal clarity, and in the case of the EU, because the EAI Act is a regulation, which is a harmonizing instrument that applies directly in the 27 EU countries, that can actually be nice because you do not have what the US has at the moment, which is different states adopting different rules for AI. So there are benefits to having a regulation in the EU that applies to all 27 countries in the same manner.
Let me ask you just so we've got this act. It's huge. It's covering a vast amount of areas. It's got very broad definitions. It excludes some things. It has a risk-based structure so that if certain things are extremely risky, they're prohibited outright. So that's things like, emotional recognition systems and social credit scoring systems that are just too intrusive. But then there's high risk areas where medical devices, vehicles, critical infrastructure, safety parts of important things like airplanes. So those are high risk areas. Those get regulated quite a bit. And then there's a much less important area, which is actually things like we use on a daily basis, our chatbots. Tell me, what obligations is this imposing where there is real risk involved? Just to get a sense of what is it compelling companies to do so we can understand a bit about that. And then we can turn to, is it really going too far or not?
A lot of the obligations relate to transparency. So to making available information about how the black boxes, I mean, basically shining a light on the black boxes to a certain extent. And then you obviously enter into a discussion about how that request or requirement for transparency can be combined with the fact that trade secrets are also protected. under EU law. So that's one of the discussions that obviously is important. And I think that is a legitimate discussion, because if as an AI developer, you've put a lot of work into creating something, you don't necessarily want all your weights of your models to be there. So that is one thing. Also, there's different elements of having to report to the AI office and to have, so that's not necessarily public, so not things that you have to share with everyone in the
Hmm.
street, but you have to be able to communicate to the AI office, and certain forms and paperwork that you need to fill in for them to be to ensure that you're complying and that you're keeping a paper trail that they can then check afterwards and do a due diligence in case of questions being asked about your model.
Hmm.
And then also, I think what is important to realize that with that category of general purpose AI, those do not fall under the risk qualification category. You don't look at the risk of a general purpose AI. They have obligations regardless of their level of risk, also related to transparency and having to show that they comply, for example, with copyright rules in terms of how they collect training data and how they process their training data. So it's a lot of it is quite burdensome in terms of reporting and in terms of having to have paperwork done and ready in case they want to come and check you, and do impact assessments, for example, of what the impact on human rights might be of what you're deploying, which for smaller companies can mean that instead of hiring an engineer, you're hiring a lawyer, or at least some of your budget is going to go to an external firm to do your compliance, because it's not something that, as a startup, for example, I don't think most startup founders have it in their genes
Hmm.
to do compliance heavily.
You mentioned assessments, impact assessment. So, given this is an act which is structured partly around risk levels, typically then, and we saw this in GDPR as well, of course, the assessment of risk. How big a part of this act is an obligation to assess the risk of your AI technology on users or on society, or Armageddon happening? What is the degree to which risk is built into assessment requirements?
That is still under discussion. I mean, basically, that is part of those code of practices that we are still waiting for, and I think there's a thin line between making those risk assessments just tick in the box type of exercises, so that people just say, "Yeah, we thought about it. Yeah, of course, we're not gonna end the world. The robots will not be our overlords. We made sure of that, and everything's fine." And then the fact that some of the in the discussions to build the codes, in some cases, maybe civil society is asking for assessments that AI developers find difficult to do or find they're not competent. I mean, it's not their skill set to necessarily understand what the impact on society is of everything they do. So it's one of those cases where asking an engineer to do ethics is it's a difficult thing, and if they're honest about their skill set, they might push back and say, well, guys, that's not what I do. But that's the difficulty of the code of practice discussions at the moment, where everyone feels the other side is not listening, but where even if all of those concerns, I mean, all of those concerns are legitimate. Trying to see how an algorithm that does influences people's lives in terms of them getting a credit or being flagged as possible doing fraud, for example, and things like that. It's extremely important, obviously, that those algorithms are used in a careful manner and that they are vetted and that they are not done used on an arbitrary basis. But the question is the company building it on its own necessarily the best person to judge that?
Mhm. So
Yeah.
there's a lot of uncertainty in the way the act will apply,
Yeah.
and it's going to come into effect next year, 2026, in full, right? So if there's this uncertainty around what it means, how it will apply, what are the risks to firms if they find they're not complying? What kind of penalties, liabilities might they have, and who's policing all that? What's European, what's national?
So, just to give all of the staggered timeline quickly, since February 2025, the rules banning dangerous AI practices have come into effect. So, the social scoring systems, those type of things. So, that's, and also a provision that a lot of people didn't spot was in there, also came into effect, and that is that companies in Europe must ensure basic AI literacy training. Except no one knows what that means, by the way. And we won't have a code of practice on that. There's been some guidelines produced. So I think it's basically trying to avoid people blindly using ChatGPT, I guess, in the company.
Maybe it means
And
mandatory listening to Trust and Trade podcast issues on AI.
that might actually be I encourage you to tell that to the European Commission and to the AI office. Maybe
They're
they'll pick
certainly
it
in
up.
favor of that.
Then from August 2025, when it comes to general purpose AI providers, they will have to meet the new transparency obligations and comply with the code of practices if we have code of practices. So that's another thing. August 2026, as you mentioned, then most of the high risk AI systems will have to comply with the stricter set of rules that will have been identified. And then by August 2027, the Act will be fully in effect, including rules for high-risk AI that are integrated into critical products like medical equipment or transportation systems. So there's still some time for companies to prepare and for things to be clarified. I should add to that, I'm not sure if that has crossed the pond up to the United States yet, that the AI Act was adopted last year, but in the same time, in the meantime, the European Commission has announced that they're going to simplify a certain number of pieces of legislation during this tenure, so for the next 4 years. And AI is one of the areas they're looking at simplifying. We're not sure what that means because the act was just adopted and is not even properly into force in its entirety. But it seems that the difficulty in terms of compliance has caught their attention. And that they are looking in the framework of what they call the AI Continent Action Plan at maybe reducing some of the compliance burden for smaller players moving forward. But as I said, it's the first time in my experience that an act that hasn't been rolled out completely is already being reconsidered in terms of its scope and scale.
And related to that, the Product Liability Directive, which the AI elements of that accompanying legislation, as we understand it, have also been pulled back. Is there in the air here both some concern about the scale, breadth, and complexity, but also some pushback across the Atlantic from the big tech companies who are, some of them, going to be very heavily affected by this legislation?
I mean, I'm not sure it's the big tech companies as such. I think there's a general mood in terms of the trade agreements and the Trump administration pushing back on other pieces of legislation that affect big tech, like the DSA and the DMA, so the Digital Services Act and the Digital Markets Act. There's been a lot of pushback already saying that those are clearly aimed at US companies and create an undue burden. And that might, I don't know, I'm not in the European Commission, but that might also be part of the equation of thinking, well, maybe we should not go too heavy on AI either. But I think there's also consideration of the EU's own AI companies. I mean, Mistral in France or Aleph Alpha in Germany, those are successful AI companies that I don't think they are insanely happy either with the compliance burden. And especially, I think, the concern that has been expressed by a lot of EU companies in the AI space is that we know that the US companies have the ability to comply with those pieces of legislation. And the danger is that the compliance burden becomes a barrier to entry for EU players, which is not, I think, what the European Commission is trying to achieve. But that makes me also worry on liability. I think what happened is normally there should have been an AI liability directive coming out that would clarify product liability of AI products to a certain extent. And that was removed from the list of legislative acts that the European Commission intends to adopt during the next 4 years. There was some pushback from the European Parliament, but I don't think they're going to be able to get that back on the list.
And so is the main liability here the companies face fines to the authorities as opposed to liability to consumers, or are there, each country has its own product liability laws which will generally apply, they just won't be as harmonized as if the European directive had come in?
So the liability, there are actually quite stringent penalties for non-compliance. So the fines can reach up to 35 million euros, which in dollars at the moment is a lot of dollars considering the exchange rate between euros and dollars. Or it can go up to 7% of annual global turnover, so not EU turnover, but global turnover for severe violations such as deploying prohibited AI systems. When it comes to high-risk AI system violations, then you can go up to 20 million euros or 4% of the global turnover. In terms of enforcement, it's managed at two levels, so both EU and national levels, because we wouldn't want to centralize too much. That would be too easy. So at the EU level, you have the AI Office, which is part of the European Commission, as I said, and they will oversee the general purpose AI models and systemic risks. So that's their core competence. And then you have the AI Board, and that brings together national regulators, so regulators of each of the 27 EU countries. And those are the regulators that are responsible for market surveillance and enforcement. And those must be designated. So each EU member state must say, okay, this is the regulatory authority that will be competent for the enforcement of the AI Act at national level. That hasn't been done completely by all the countries yet, I imagine, because in some cases there must be turf wars on who wants to do the cool thing, which is AI, or maybe no one wants to do it. Could be that too. But so we will have two layers of enforcement, and that obviously is the element where some level of non-harmonization might take place, because an Italian regulator might not look at compliance in the same way as a German regulator would, for example.
Mhm.
So that's where the concern comes, and we've seen it with GDPR too, where there's a lot of pushback on the Irish regulator not being forceful enough compared to the French or the German, for example. There's a bit of a name and shame between regulators happening. So we could have that too when it comes to the AI Act.
And liability to consumers who may suffer, or the individuals who may suffer as a result of an AI decision or product malfunctioning, or incorrectly deciding whether a person should, for example, be granted a loan or not. Is that kind of liability to the consumer also going to exist under the national laws, or is this purely about being fined by the authorities?
The AI Act, as I understand it, is purely between the authorities and the AI developers, importers, etc. But obviously, Europe has very strong consumer protection laws that can apply even if it is AI, let's say, that if the outcome is not good. And we have a Product Liability Act that's, even if it doesn't say AI, it still applies to products that are, and those products can be digital, that are delivered on in the EU. To what extent it will be easy for a consumer to bring a case and to prove the causality between a decision, the AI, etc., one would imagine that maybe the AI regulatory authorities or the AI office would have to help, or would have to be triggered into going to look into things. But honestly, at this stage, I'm not sure how that will function. I think what is interesting too is that since the past couple of years in the EU, we also have the possibility for consumer organizations to bring cases, something that the US does a lot. I mean, you guys have a lot of that. It wasn't something that is widespread in the EU, but that is now happening, that you can expect, I think, consumer organizations to stand up in case of abuses.
Mhm.
And then a final element, but I don't think it will cover AI, is there is a Digital Fairness Act that is on the agenda to be, a proposal should come out next year in 2026. Maybe there will be some element of fairness that also pertains to AI that we don't know.
I suppose taking a step back then from the enforcement side of things and coming back into the vein of the impacts that the Act might have, something I'd be very interested to get your thoughts on. You've engaged in significant thought leadership about the risk of output filters and preemptive censorship as a knock-on of the Act as it's currently drafted. And I know you've been an avid advocate before for policymakers to reject the implementation of those concepts. So can you kind of talk us through where you see the EU is standing on those concepts now, and whether the risk of preemptive censorship, for example, remains a likely impact of the Act?
Oh, I mean, absolutely. I think what's at stake obviously is that when you look at general purpose AI models, we as users deliver prompts to them. We ask them questions, we ask them to produce images and all kinds of things. And you may already, or users may already have experienced that in some cases, the chatbot refuses to give you an answer because it says, this does not comply with our general terms and conditions, or I cannot provide you an answer of this on this because it's my model does not allow me to, or whatever very polite answer, because usually chatbots are extremely polite, they will give. And what you can see is that there's different categories of reasons, or you can guess because it's not very transparent. In some cases, it might be because they're afraid of a copyright infringement, for example, because you're asking them, I don't know, Mickey Mouse or something. In some cases, it might be because what you're asking is dangerous, because you're asking how to build a bomb, or you're asking things that are bad for health or whatever. And there have been studies done by people like Professor Mshangama, where he said that there's actually a very high level of self-censorship that is built in within the chatbots because of the risk of liability. And having been active on upload filters on content platforms like YouTube before, the question you had there when looking at filters on platforms was a question of freedom of speech. Obviously, if platforms censor what you want to put as a user on YouTube or on Twitter or on, that is censoring your, or that is affecting your freedom of speech, and that can be obviously a fundamental rights concern. But when you talk to a chatbot, that is not even speech. You're basically brainstorming with a chatbot. You're one on one and you're exchanging thoughts. So you're actually going one level deeper, which is your freedom of thought is being affected in your conversations. And in some cases, the foundation model will have Anglo Saxon views, so American views, let's say, if it's a chat GPT. In some cases, you will be talking to DeepSeek, and those will be Chinese values that will affect your freedom of thought. At the moment, aside from Mistral, for example, there's not many places where I get my European values in terms of my freedom of thought. Let's put it that way. To me, that is concerning because it's totally not on the agenda of policymakers. There's no thought. I think most users just shrug it away at the moment, thinking, okay, too bad, I'll try something else or whatever. But with AI being prevalent in everything we use, you're writing a document in Office or in Google Docs or whatever, the AI assistant is there. And that means that the filters are there too. So you don't know if at some point, even what you write, Gemini or ChatGPT or whatever other application might tell you, well, I don't think you should write that because that could be an issue. And that concerns me, quite honestly, because I think that dimension hasn't been looked at all at the moment. It goes back to the intersection of the AI Act with other provisions and with other rules, where I had to laugh that some members of the Council of the EU, so the place where the governments of the EU member states come together, some of them asked to get matrices built of the intersection of the AI Act with other provisions because they just don't understand how they mix and match.
And touching on that point that you made earlier on, that policymakers were compelled to provide solutions and they kind of had to act first, it seems that they've really placed a human-centric focus and safety kind of at the core of all of this, at largely the expense of other fundamental freedoms to some extent. And that was something that we spoke about last week with the New Bradford. We discussed that dichotomy between a choice of effective regulation and protecting digital rights on one side versus digital innovation on the other side. And I suppose something that we'd also like to draw out on this episode is whether you think this overly cautious approach can chill creativity and innovation, or whether it already has, or whether that's something that we're going to see over the next couple of years. You obviously spoke about the timeline, so whether you think that's going to just increase year on year as the AI Act is rolled out.
My fear is always that when the EU wants to react quickly to something, I don't consider it's necessarily bad to try and create a framework and draw red lines around certain innovation and technology. But in most cases, the end result goes beyond the intention. Let's put it that way, to put it politely. And in this case, I think the level of micromanagement they went into is one that scares off a lot of companies in terms of deploying products and solutions in the EU. What usually happens then is that a lot of companies just go elsewhere, even if there are Europeans involved. They prefer to go and install themselves in other countries to create their models, and then afterwards they try to see if deploying them in the EU, knowing the extraterritoriality of the AI Act, if it's worth it or not worth it, or if only some features of their products will be available or not. And then we come to a situation where, on the one hand, the EU is losing its innovation to other geographies, and then we're actually not having access to full products anymore because of the limits that are put there. I'm hoping that with the simplification agenda that is now there, and with the fact that there are these codes of practice, that some form of common sense will get in, and that they try to. I would like those codes of practices to be at the level of principles and of being helpful and suggesting solutions to those companies that are too small to invent solutions, but that also allow bigger companies, for example, to find their tone and find their solution and achieve the same result, but maybe through other means. The other thing I'm always concerned with is I don't want it also to go into techno solutionism and to just for them to say, well, you've created problems with AI, nerd harder and find a solution with AI. I don't think that's useful either. So it's very challenging when something new happens for a legislator to understand how they need to create the right framework. And I would honestly have wished for the EU to take one more year before adopting the EU AI Act, not do 3 days of negotiations with very little sleep, but just have accepted that maybe we need a bit more time and more impact assessments to adopt this act. Now we have it. As I said, it does have benefits. It tries to protect consumers from abuses, it tries to do good things. Let's hope that with the enforcement, they keep the objective and the goal in their mind and don't go into micromanagement.
Nina, Rory, I'm skeptical when companies ask for light touch regulation. Light touch regulation is oftentimes just a way of talking about externalizing risks. But within the first two episodes of this series, we have seen at one poll jurisdictions that don't have any kind of regulation in place, prompting Nina in the first episode to wonder whether they would be regulating after Pandora's box had been opened. And in this episode, at another poll, you have 450 pages of debated and hashed out regulation that, due to a combination of regime change and shifting economic winds, is already being reconsidered, which leaves practitioners in this space almost having to work on two axes. One, what does the law say now? And two, where is policy heading in this field? What are the key takeaways here for practitioners? Nina, let's start with you.
I think it's clear that we still have a long way to go in terms of what way the EU AI Act is going to impact businesses and users, really. And obviously, we need a common sense approach from policymakers to really adapt things as they go forward. Obviously, Caroline, you mentioned there's recitals still in the Act that don't have a corresponding article. Kind of how that's going to play out over the next couple of years will be interesting. But I think practitioners need to be alive to also seeing how the framework works for them and their clients and how this progresses over the next few years, and to really lobby and speak up if it's not working and say why it's not working from a common sense perspective. So to touch on, I guess, that thread that's been running through this whole episode, the Brussels effect again, it's a different take on the Brussels effect to an extent. People may not be regulating like the EU in one sense, but they may be learning from the EU. And I think that's something that we need to be alive to as the next few years come in. It's not a case that it's a set in stone framework, more of a living framework to an extent as we see how AI develops.
That living element, Nina, I think you're absolutely right. This is it's like an interactive process live between regulators and the developers and others who are putting these products onto the market, and everybody is learning as they go. And I guess the EU is struggling with that core principle that Victor mentioned last time, that you want to have this learning built into the regulatory process. You don't want to fix things, ossify them too soon so that they're anchored for too long without flexibility to change. And I guess that's a core struggle we're seeing here live in the European Union. I mean, it clearly has this deep kind of human-centered focus that Victor also talked about last time, that it's really trying to make sure people are genuinely protected. It's socially anchored in terms of trying to deal with real use case situations. But I think Caroline's really helped us understand that perhaps it's gone a bit too far in trying to regulate use cases individually as opposed to a more principled approach. So clearly, practitioners, Anant, I think practitioners have to keep their eye on this and engage. The other thing that comes out, and it goes back to what Anu Bradford was talking about last time in terms of the market power of some of the big tech companies. Caroline, I think, really shed a light there on the potential regulatory burden being a barrier to entry and growth by competitive players, and even Europeans, who it may be backfiring a little bit on some of the Europeans. So we will see as time goes on how the authorities juggle all of these things and work out a way forward. But thank you so much, Caroline, for your input today. It's been really very insightful. Thank you. Anant?
Yes, thank you, Caroline de Kock, Rory, Nina. Yet another great episode in our ongoing series examining global approaches to regulating artificial intelligence. Stay tuned for future episodes as we examine approaches being taken in other parts of the world. And to our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.